Hello, everyone, and thanks for joining today's show. The Supreme Court has ruled on OSHA's COVID rule, and you need to find out what you need to do immediately. So, big news, right? We've been reporting on this for, boy, I guess it is since early September when the Biden administration first issued the vaccine mandate. And finally, in November, we got the rules for implementation from OSHA. And since then, it's been nothing but legal battles in and out of courts. And finally, January 7th, Supreme Court went into special session to meet on this highly controversial topic. Lots of people for it, lots of people against it. We're not taking any sides here. All we want to do is share the very best information we possibly can. But we finally have news, and I can't think of a better person to break down this news and really specifically what does it mean for small and mid-sized businesses than today's guest, Adam Gattel. So Adam joins us. He's a principal attorney in the Long Island office of Jackson & Lewis. Jackson & Lewis is what I would call probably one of the premier law firms around HR in the United States. Adam is New York based, but Adam, what do you guys have? About 950 plus attorneys in your firm covering nationwide HR issues?
That's right, Mike. We've got we're almost touching 1,000, and we do exclusively management side labor and employment work, broken down by every type of labor and employment issue. So you've got employment litigators, you've got pure folks doing labor, union work, benefits specialists, contracts, anything having to do with employment, and we work with employers around the country in 60 plus offices.
Well, that's great. So it's a pleasure to have you on the show today, Adam, and really enjoy looking forward to tapping into your expertise. So I think by now, and anybody who signed up for this webinar today kind of knows the big punchline here, right? That the Supreme Court struck down the mandate, but it's probably a little more nuanced than that. So I want to talk about what didn't get struck down, healthcare business industry versus larger employers, and then get into a little bit of the why, because I think the why matters. So maybe first, Adam, just share with us, what was the court's ruling?
Sure. And thanks again. I want to thank Assure for inviting me today. It's my pleasure to do this. Not to get too lawyerly on you, but there was really sort of two cases going on, or two decisions here. And what the court did was they granted a stay, right? So all the petitioners, the people, really the state's attorneys general, who were pushing back against the OSHA emergency and temporary standard. That's what people have been colloquially calling the Biden vaccine mandate. Said, we don't want this to go into effect. And it did go into effect, and they made this motion that went all the way up to the Supreme Court. And the Supreme Court, in this pretty public decision, said, we're going to stay it, meaning the rule cannot go into effect, pending some other stuff that's going to happen, not to get too much into the legal wrangling on this. But usually this is the whole ball game. So this decision is going to be quoted by many attorneys general, many people who are against this particular mandate. And I think it's somewhat of a misnomer to call it a vaccine mandate, because it's really a vaccine or test rule that was pushed out by the Biden administration through OSHA, which is the administrative arm for occupational safety in the workplace. That's how they decided to do this particular aspect of that rule. And the rule was, if you're an employer who employs 100 or more employees, you had to set up a system, with certain deadlines within your workspace to require every employee to get vaccinated, and they could have the option of testing on some sort of regular interval to make sure that they were not COVID positive and coming into the workspace. So it was really vaccine or test. That was the OSHA rule. There was also another rule that was set up by the Centers for Medicare and Medicaid Services, which is different than OSHA, that required healthcare employers, which is a specific definition, I can get into that in a minute, to have everyone in their workspace get vaccinated, right? And there was no testing option with that. The court upheld that rule. So right now there is a requirement, if you are a Medicare or Medicaid provider in the healthcare setting, your employees must be vaccinated. And we can talk about the nuances of that. But the big news story was that the vaccine or test, which I think is estimated to affect some tremendous amount of employees and employers around the country, that was stayed or struck down, however you want to say it. And what that means is that employers are not required to set up this particular type of mandate in the workspace. It never applied, by the way, to employers under 100 employees. But for those who are 100 and over, which are a lot of employers, that's still generally a small business in this country. They were going to have to set up this rule, and now they don't.
Can you speak a little bit to the why, Adam? So as I understand it, and I'm no attorney, but as it seems to me that the healthcare providers, there was a clear line of demarcation where because they're in the service of providing healthcare services to clients, that seemed to be a reasonable reason why you would put some type of a set of rules, this ETS, the emergency temporary standard, in place for them. But to put this on employers of greater than 100 employees seemed a bit more arbitrary. So why would a 101 person company have to do this versus a 90 person company when a 5 or 10 person company has to comply with OSHA standards otherwise?
Right.
Do I have that right?
Yep, excellent point. I mean, the only thing I would change with that question is that there's really two rules. There's the healthcare one, and then there's the ETS. They really are separate rules, and I can explain how that's different. But I think you raise an excellent point as to the why, right? You can quit. I think reasonable people can take a position on sort of the court's philosophy, and we can break this down into political leanings. What justices were appointed by which president, and do they, feel one way about, certain philosophical issues as opposed to others. I actually think the court's reasoning, at least in the majority opinion on both, make a lot of sense outside of politics, right? The way that they explain it. Now, are they informed by some sort of political leaning? I'm not going to make that judgment. But the decision and the reasoning is actually pretty clear. So what happens is, let's say in the ETS case, right? That's a separate case with 100 or more employers. The court basically said, yes, OSHA has the authority to regulate the workspace to prevent, dangerous conditions. That's OSHA's, job.
That's
OSHA, right. OSHA can say to certain workspaces, you're in manufacturing, you have to have certain protections in place. If someone's on an assembly line, they have to, you have to wear certain protective materials. You can't have, you have to have guardrails if people are working in high spaces, all this sort of things that protect the workspace, dangerous chemicals, all of that. And what the court said, they looked at that and they said, this rule, even though it's pushed out through OSHA, doesn't get down to the finer points of a particular workspace. It's saying all employers, regardless of what you're doing, whether you're sitting at a desk, in a spread out workspace, or if you're on an assembly line with people breathing on top of each other, are bound by the same mandate, right? And that's where the court took issue with the Biden, whatever we want to call it, let's call it the Biden rule, right? They took issue with that, saying that's too broad. What I take away from that is the court's also saying to the administration, you want to go back to the drawing board and fashion a rule for particular types of workspaces. Take it, for example, assembly lines or places where people are there's a real risk of catching COVID because people are in close proximity to each other. Maybe we take a second look at that and maybe uphold that and say that's within OSHA's authority. So for that reason, that was really the main reasoning in the court's decision on the ETS. The healthcare one in a minute, that's different.
Yeah, and not to delve into the political, but ironically, I think one of the struggles for small businesses in the last, call it 2 years, year and a half, has been, you've got government agencies, say like a CDC, providing guidance, but CDC doesn't have teeth, where OSHA has teeth. And so the attempt from the administration was, how do we get the maximum number of people vaccinated as possible in a way that we could still administer? Therefore, they end up with this rule. They ironically might have had more success had they said it was for all employers under OSHA's governance, I guess. Is that fair to say?
Yeah, I mean, all employers pretty much are. Here's the issue, and I think everyone can sort of play Monday morning quarterback or whatever. I recall a time, a year ago, months ago or whatever, where certain employers wanted to mandate the vaccine and they were getting pushback and stuff. And sort of the conventional wisdom was, if only the government had our back on this, and maybe they mandate it, and so then we can say, oh, it's not our fault, it's just the government who's forcing us to do that. That would help certain employers, implement a mandate. That's obviously been turned on its head, and then, we end up with this case. So, I don't know I'm not going to try to ascribe, someone's motivation one way or another to how you push out a rule. But I guess my final point is that this particular decision leaves the door open to more rules. It doesn't say OSHA doesn't have the right to, police the workspace. It just says in this sort of, broad context, it's not going to enforce it.
Yeah, and it's, and honestly, it's neither here nor there, but I did think it was an important conversation. Everybody understands kind of the why. So I think maybe what is actionable for people listening to this? So if you're part of a small, medium-sized company, you're a growing company, if you're obviously over 100 employees, this for sure impacted you. But regardless of employee size, how should, and I'm going to switch to our next topic here, how does this impact, the court's decision impact, or I think more importantly, not impact, other mandates? Does this mean that if my governor or my county health official put out some standard that I must follow, whether I love it or hate it, can I say, hey, the Supreme Court shut this down, I don't have to follow this?
You don't have to follow this, but there are other laws and rules you have to follow. And you raised the point, I think, in sort of the last topic where you said, hey, employers may be upset because there's too much regulation and it's very tough to run a business. One of the criticisms of this rule was that the testing option, right? So if you have, employees that say, okay, a bunch will get vaccinated, and others say, well, I'm going to pick this testing option. The federal rule did not identify who paid for what, right? It just says it has to get done. That then, and this leads into your next question, this then falls on the locality, right? So New York, for example, has some pretty tough wage and hour laws. So if an employer had to do the federal mandate, and you had employees who chose to take the test instead of prove that they were vaccinated, if you as the employer said, okay, we're going to do this, and you have to present a negative test every Monday at 9 a.m. or whatever your rule is going to be in place, you were required as the employer to pay for that time under New York law. If you have a non-exempt employee, someone who's an hourly employee going in, and we know the issue with testing in the last couple of weeks, it's short supply and all of that. And if someone's waiting online Monday morning for 2 hours and then their insurance doesn't cover the test and they got to pay for the test, all of that was falling back on the employer to compensate that employee from. So that was one of those things that was a little challenging on the employer. You should know, and this is where, why employment attorneys exist, you should talk to people who know, whether it's your HR professional or your attorney, as to whether or not there are local or state rules and laws that apply to you. For example, as you mentioned, I'm in New York City. I think it was December 27th under the last mayoral administration put in a vaccine mandate, not a testing mandate, but a vaccine mandate for all size employers that required everyone, operating in New York City to actually prove vaccination. So that's a New York rule, which is obviously more rigid than what the federal government was proposing. New York State right now has a mask mandate. So there are different rules and laws that are in place. So just because this doesn't exist, there may be something in your locality. There are states, that swing the other direction completely, that will actually say that employers can't put in a mask mandate, things like that. So that definitely know where you are in terms of where you're doing business.
And I want to kind of swing away from the Supreme Court decision in this particular, the ETS around the Biden administration's mandate here, because I think that this is probably one of the most confusing things for especially small businesses. I think you got a client, so let's say you're a local retailer, and I know this is like real life story. A friend of mine owns a business locally, and clients come in and lots of strong opinions, pro and against, pro and anti-mask, and quite literally, you'll have the county executive has an order requiring masks. you have a local mayor of a city, a municipality that sits within that county that says, no, we're not going to enforce that. We've always been guiding clients that, you know, when you have to follow the law no matter what, but A, you got to follow the most local law, and then B, if you always err on the side of employee safety, that's probably the safest path you can take. What guidance, so forget the Supreme Court deal, the national deal, what guidance do you have for small and mid-sized businesses on the local level who are inevitably facing conflicting rules and regulations on this?
Yep, no, excellent point. So if you are an employer that has some of those conflicting rules, you hit it the nail on the head, which is there's tension between, you know, following, you know, doing business, keeping your customers coming in, and then also keeping your employees safe. You know, if you don't have look, I'm not aware of a locality that is so anti whatever with respect to the laws that it's set up a dangerous condition. But like you said, there may be a locality that says we're not going to enforce the mask mandate, right? So you as the employer may have the option to enforce a mask mandate, and then you have to decide whether or not that's something that's going to, you know, drive business to you or drive business away from you. The tension with that, let's say you're in a locality where you think that's going to drive business away from you. You then have to protect your employees too. That's the tension. So if you have employees, for example, who get sick with COVID and ill, you know, they could have a claim against you to say, hey, you did not have a safe environment. And, you know, I was confronted with, you know, customers coming in and, you know, and there was no, you know, you weren't enforcing the state rule, which we thought you should. And therefore, I think you're responsible for my illness and I've been damaged and we're going to sue you. We saw that early on in the pandemic with some very large national retailers where there's some class actions started by, you know, before anyone really knew what was going on. These lawsuits read almost like the CDC guidance, where it said the employer was negligent in that they didn't do the following. And it was just a laundry list within the complaint of all the things that employers should be doing to protect their workspace. So you want to do that. You want to do things to protect your employees. You want to keep people employed. You know, we know with this current variant, we've all been affected. You know, I had a flight canceled right before the holidays because all of a sudden, you know, there weren't pilots and flight attendants, you know, because everyone was coming down and being ill. So you have to keep people working, but you also have to keep them working in a safe environment. You know, not that we can give legal advice in this kind of setting, but you want to do what's right for your business, and you really want to consult your HR professional or your attorney about this. So there is a balance. There's definitely a real balance, right? And I think, you know, I'll wait for the next question, but one topic that I think we should discuss is probably, you know, if you wanted to put in a vaccine mandate, because there's nothing that prevents you from doing that, what are your considerations, you know, in that, because you want to keep people employed. You don't want to lose employees either.
Yeah, you know, that's a perfect segue. So let's just go there. And I guess I want to spend a little time on this one because I think we contemplated the question, knowing that some employers think, thank God the Supreme Court sided with me on this, and some are thinking, how dare that conservative court decide that way because they are for the mandate. Obviously, people have their strong opinions on all ends. It's a spectrum here.
Yep.
But there are going to be some companies who are going to want to implement exactly what the OSHA ETS laid out, and maybe even stronger rules and regulations. There might be some people who want to defy local ordinances and do that. Let's talk about a couple of scenarios. So first, what about the company who wants to implement a mandate of some type that now doesn't have the backing of being a federal requirement?
Right. No, I got that. And I've worked with a bunch of companies early on before the federal government, you know, really even got involved in this, who wanted to get ahead of it. They felt very strongly, in particular some healthcare organizations, that they wanted a mandate. There is nothing illegal about mandating that your employees get vaccinated, right? But you have to make exceptions to comply with the law. So you could have a vaccine mandate that says, you know, we require all employees to get vaccinated by such and such a date, and you can set forth even the specific deadlines for the first shot, the second shot. I've even seen now employers, you know, requiring a booster. But you have to make exceptions under the Americans with Disability Act, and that's a federal law, and any sort of state or local law with respect to disability claims, that if an employee comes to you with a reasonable health exception, that you got to work with them. You have to engage in what's known as the interactive process to see if there is a reasonable accommodation that allows them to continue performing the essential functions of that job. There's the health one, and there's also religion. I'll get to religion in a minute. But so you can mandate, say, everyone in the workspace has to get vaccinated, but we will discuss potential accommodations for health or religion. And the way that works is that someone comes to you with a reasonable, with a real doctor's note that says, for whatever reason, my patient, should not be vaccinated, and we're asking that you make an accommodation for that person. And then you have to engage in this interactive process and a back and forth as to what that accommodation could be. Is this someone, for example, and we've seen these notes where someone recently was infected with COVID, they've recovered, and a doctor says, we do not recommend that they get the vaccine for a certain period of time. That's fine. That's a short-term accommodation, and at some point they'd be able to get the vaccine and comply with your policy. Maybe they have a health condition where they have a specialist in something so nuanced where the doctor says they really should not get this vaccine for whatever reason. You want to work with that person. If that person still presents a direct threat to the workspace, there may not be an accommodation. Are you working on an assembly line where everyone's breathing on each other and there's really no way to give them an accommodation, or have them work elsewhere, and proper PPE is not sufficient enough to prevent the transmission of COVID? Maybe there's a way that maybe they can't be accommodated, but that's a really detailed analysis. The other one is religion. If someone comes to you and says, I have a sincerely held religious belief, and they explain it, you really can't push back against that. It's very hard. Early on, we had companies who wanted to push back against that, but that's been held by courts across this country that as long as someone expresses a sincerely held religious belief, it's really difficult to challenge it. You can ask questions. You can do sort of a searching analysis. If that person then changes it from a religious to maybe a political belief, that obviously is not protected, but it's really just religion. And, again, this is a very fact-specific inquiry as to what you have to look at and how you can talk about accommodations with those people who seek those sorts of accommodations. But though that's really what you can do as an employer. You can be aggressive about it. You can have a mandate in place, but you got to work within the law to accommodate those folks who won't or can't comply with the mandate for religious or health reasons. And by the way, the other Supreme Court case that upheld the mandate for Medicare and Medicaid service providers did so on those grounds, saying, there's no testing option. You just have to make exceptions for religion or health.
Got it. How about, and we kind of touched this in the previous, I just want to make it really clear what I think the answer is. What about those who want to defy, so the person who says, okay, my local county official, county executive says masks must be worn. Well, I don't believe in masks, so I'm not going to enforce my employees to do it. Is there any legal ground for doing so?
Not unless they want to spend money on lawyers and fines and what have you. I mean, yes, you can, like any law that you disagree with, if that's not, a criminal law, right? If this is some sort of like local ordinance, let's say, I'll give you an example, right? So early on in the pandemic, I worked with a company that was a builder, and there was a rule or a law that went into effect in a local ordinance that said something like no more than one person at a time can be on a residential job site. Which, looking back on that and what we know about COVID now, that seems kind of arbitrary, and it's weird, it's sort of an odd law or ordinance. Someone I know, this company, they went and not on purpose ended up having two people on the site at a time. They got cited and got this like ridiculous fine for doing that under the way that this law was written. And I say ridiculous, someone was there for 2 minutes to try to install something while someone else was dropping off a part. And the local government said, no, we're enforcing this. This is the law. This is what we're going to do. So you can spend the money and fight that. And there is a way to fight that. You go to court, and under every court, every state has its own mechanism, to challenge the rule or the law within the courts. I mean, remember that the laws are set up by the legislative body. The courts are there to interpret the law. So that, my client in that case said, do I want to fight this and say that I think this rule is wrong? Yes, you have the option to do that. But at the end of the day, the amount of money you're going to spend to fight that may well exceed what the fine was. So that's your opportunity, and that's probably about it. you know, depending upon how strong the enforcing authority is in your locality, is really going to be, you know, the issue. You know, I as a lawyer, I'll tell you, follow the law. You know, you should not try to challenge the law, because you'll have to. That's your only option, is to really then go to court and challenge it. You will be in violation of the law, and the enforcing authority will probably enforce it against you. And
Yeah.
especially the ones, let me just make this point, the one with the fines, right? So what is every government, you know, locality, municipality, you know, if you've got a law where the remedy is a fine, that the authority is going to want to collect that fine, because that's revenue. So it's, you know, I don't see them backing down on that.
No, I think that's good advice. Adam, what maybe closing thoughts would you have for employers as we think about this? You know, I look at the numbers every day. Obviously, the Omicron cases has exploded. You know, maybe we hit the peak, maybe we didn't. The ETS, you know, is an emergency temporary standard, right? So it's always temporary. It was a 6-month deal. And I don't know how comfortable you are, you know, looking into a crystal ball here, but what do you think, if any, we should expect around, you know, further rules from OSHA, or direction from the administration, or just how should employers be thinking about this whole topic around vaccines and mandates and OSHA on a go-forward basis?
Yep. Look, the way I see it, and I just give you, I'm putting my lawyer hat, I'm not going to give you an opinion on this. This is just really sort of what I'm seeing on the ground. One is, and this was my initial reaction to the court's decision, they opened the door to saying, you know, OSHA has the authority to issue some mandates, but you got to do so on a more narrow basis. Certain industries, certain types of workspaces. I could see OSHA doing that. And then the employer in those industries certainly have no choice. They would have to follow the OSHA rule. I mean, of course, this could be challenged again, but I think, you know, if it's within the contours of this decision, you know, the challenge would probably be unlikely. As an employment attorney, you know, who sees a lot of litigation, I'm primarily a litigator. I defend employers when they get sued by current and former employees. I would tell you, do what you can to avoid litigation. You want to keep your workers safe. And so if that means voluntary rules and policies in the workspace that are legal, to do things to keep your employees safe, even if they may not be that popular, you know, that's my recommendation, because, you know, what you don't want is a lawsuit from an employee or a class of employees, which would be even worse, a class action saying, my employer flouted these rules. My employer did not provide a safe environment for me. You know, you're running a business, and your goal is to have everyone there and have them working, but also be safe about it. You know, and when you raised earlier the issue of what about localities, right? There's a lot of local rules that if you're not complying with those, the states, for example, have set up mechanisms for that employee to not even have to just go get a lawyer. They can go to the regulating authority and say, hey, I want to complain about my employer. They didn't give me the time off. You know, I told them I was sick with COVID and I proved it. They didn't give me the time off. They were supposed to give me pay for that. Or, you know, they put me in a dangerous condition. You know, it's a lot harder to deal with those agencies than even just a private lawsuit, because there's not really anyone to negotiate with. A private lawsuit, they're just looking for money. With an agency, you know, there may be fines and penalties assessed, but they're also going to start looking into other things. So I would say comply with the laws. Look at your workspace. How can you make it safe while still operating your business? That's what I'd be looking at.
All right. Well, Ed, very much enjoyed the conversation, and I think if anything, anybody listening today realizes, hey, the decision of the court seems pretty black and white, but this whole issue around workplace safety, what do I have to comply with? What do I not comply with? What are federal versus state versus local regulations? This stuff is complex. In knowing what to do in real time and having these conversations with employees is difficult. So at most smaller growing companies, HR is someone's part-time job. So whether you're a small company, you need a little bit of help just to help support your managers or owners and kind of navigate these waters, or you want a fully outsourced team, but you don't have the financial wherewithal to hire, you know, a $75,000, $100,000 a year SHRM certified HR professional. You need something more on a fractional basis, but who can really be that voice of reason, understand what you can and can't do in the laws, provide the right kind of training and orientation in personnel experience for your employees. This is what we do. We understand the laws. We have SHRM certified professionals that can act as your outsourced HR department. It's just really a fraction of what you could ever do in-house in bringing this level of expertise, including our partner Jackson Lewis, whom we rely on when we need legal advice on what's inbounds and out of bounds. But then beyond that, Adam, I will give you a second here to talk about your firm, because there still are always going to be some situations where you need the real pro and you need an attorney. So maybe just a second, tell us about your firm.
Sure. No, I appreciate that. As I mentioned at the outset, we are a full service employment firm. We represent management only, in everything from defending claims of discrimination, harassment, retaliation, to giving advice on a regular basis for, to make sure you're doing everything to be compliant, whether it's benefits. We don't step on Assure's toes with respect to HR, but partner with them. And really, we go so far as if you've got, non-compete agreements in place with your employees, you want to protect your protectable interests, we'll work with you on that. Really anything you need. We also publish a ton of content, so feel free to go to our website. If you need to contact me, I'm on the website, you can look me up. But if you go on our website, you'll see we've published really content about all the different regulations with respect to COVID so we have a dedicated COVID area that you can look at if you want to just glance over that. But we're happy to help with any situation.
Well, great. Well, Assure is in the business of helping small and mid-sized companies grow by providing payroll, HR, time and attendance, and HR services. Let us worry about the administrative tasks so you can put your budget, time, effort, and energy into growing your business. So with that, Adam, thank you so much. I learned a lot, and hopefully our audience did too. And until next time, thanks for joining, everyone.
Thank you. Thanks for including me.